So, Assalamualaikum warahmatullahi wabarakatuh. My name is Sarah Noresha Lulu binti Muhammad Zahrir, and my metric number is 060175. So now I will be presenting on the topic of war crimes. So for today's agenda, I will be talking about the background of war crimes, introduction of the war crimes, what is war crimes, the war crimes tribunal, did you know question, elements of war crimes, the cases, and the conclusion. So for the background of war crimes, the concept of war crimes emerged specifically at the end of the 19th and the beginning of the 20th centuries, when international humanitarian law, also known as the law of armed conflict, was codified. The concept of war crimes emerged specifically at the end of the 19th and at the beginning of the 20th centuries. So even though the prohibition of specific conduct in the conduct of armed conflict can be traced back many centuries, the restrictions of specific means and methods of warfare is the main subject of the Hague Conventions, which were adopted in 1899 and 1907. Since then, a number of further related treaties have been ratified. The protection of those who are not or are no longer participating in hostilities is the main subject of the Geneva Convention of 1864 and subsequent Geneva Conventions, including the four Geneva Conventions of 1949 and the two additional protocols of 1977. So several of the violations of its rules and classified as war crimes under both Geneva and Hague law, albeit not all of them are. International law does not, however, contain a single text that codifies all war crimes. Both international criminal law and international humanitarian law treaties, as well as international customary law, contain lists of war crimes. The additional protocols and other international humanitarian law accords have not yet attained the same level of recognition as the 1949 Geneva Convention, which have been ratified by all United Nations members. So what is war crimes? According to international treaties and customary law, a war crime is a major infraction of the laws or conventions of war. It has been challenging to precisely define the word war crime, and usage has changed frequently, especially after the end of World War One. So the instructions for the Government of Armies of the United States in the field, also known as the Lieber Code after its primary author, Francis Lieber, was published by the U.S. President Abraham Lincoln during the American Civil War and distributed to Union military personnel in 1863. It was the first comprehensive attempt to define a wide range of war crimes. For the introduction to war crimes, for use by international war crimes tribunals, definitions of war crimes have lately been formalized in international legislation, such as those establishing the International Criminal Court and the war crimes tribunals in Yugoslavia and Rwanda. The modern definitions, in contrast to earlier ones, are more inclusive and penalize specific actions taken by both citizens and military personnel. So a special commission on the responsibility of the authors of the war and on enforcement of penalties was established by the victorious Allies immediately after World War One. According to the Commission's recommendation, war crimes trials should take place before national courts of the winners, and when needed, an inter-allied tribunal. The initial list of approximately 900 suspected war criminals was created by the Allies and given to Germany. In the years following World War II, Europe and Asia made their next significant effort to try war criminals in court. The Allies had repeatedly declared their willingness to punish war criminals while citing atrocities carried out by Adolf Hitler's Nazi dictatorship. The Moscow Declaration of 1943, signed by the United States, Great Britain, and the Soviet Union, and the Potsdam Declaration of 1945, signed by the United States, Great Britain, and China, which was eventually enacted by the Soviet Union, both addressed the matter of imprisoning war crimes perpetrated by the German and Japanese government respectively. So what is war crimes? So war crimes is a breach of the rules of war. So the Geneva Conventions, among other multilateral agreements, have established the legal definition of war crimes. The Rome Statute of the International Criminal Court, which was adopted more recently, is the most complete legislative declaration on war crimes. So the victim must be shielded from liability by the Geneva Conventions in order for there to be a war crime. Soldiers are subjected to GC 1, 2, and 3, while unlawful combatants and civilians are subjected to GC 4. So according to Rome Statute Article 8, the following actions constitute war crimes. So the actions are willful killing, torture, biological experiments, mutilation, unjustified destruction, and appropriation of property, conscripting prisoners of war, denying prisoners of war a fair trial, unlawful deportation or transfer, unlawful confinement, taking of hostages, pillaging, intentional attacks against civilians, intentional attacks against non-military targets, intentional attacks against peacekeepers or humanitarian aid groups, killing or wounding combatants who have surrendered, employing poison weapons, rape, sexual slavery, and forced sterilization, forced pregnancy, and conscripting children under the age of 15. So basically for taking of hostages and conscripting children under the age of 15 can be found in the case of the prosecutor against Thomas Lubanga Dilo. So basically, Thomas Lubanga Dilo was found guilty on 14th of March 2012 of the war crimes of enlisting and conscripting of children under the age of 15 years old. So he founded and led the Union of Congolese Patriots and was a key player in the Ituri conflict. To continue, for Rwanda and Yugoslavia war crimes tribunals, between the Nuremberg and Tokyo trials and the subsequent official international prosecution of war crimes, nearly 50 years had elapsed. The United Nations Security Council established the International Criminal Tribunal for the prosecution of persons responsible for serious violations of international humanitarian law committed in the territory of the former Yugoslavia since 1991, or the ICTY, in May 1993 in an effort to stop further instances of ethnic cleansing in the dispute between states of the former Yugoslavia and to bring peace and stability to the Balkan region. So the International Criminal Tribunal for the prosecution of persons responsible for genocide and other serious violations of international humanitarian law committed in the territory of Rwanda and Rwandan citizens responsible for genocide and other such violations committed in the territory of neighboring states between 1st of January and 31st of December 1994, was established by the UN in November 1994 in response to allegations of genocide in Rwanda. So both the ICTY and ICTR had an international membership, and neither tribunal was based in the nation where the relevant conflict took place. Instead, they were both in Arusha, Tanzania. The tribunals shared an appellate chamber and had essentially identical controlling legislation. The Nuremberg and Tokyo tribunals had the authority to execute defendants, while only prison sentences could be handed down by the ICTR and ICTY to house those found guilty of war crimes by the tribunals. However, no unified international prison system was formed. So did you know that the ICTY and ICTR statutes did not see an individual's official position, including his role as head of state, as a sufficient foundation for avoiding or evading criminal accountability, similar to the Nuremberg and Tokyo Tribunal statutes? Slobodan Milosevic, the president of Serbia from the year of 1989 to 1997, and Yugoslavia from the year of 1997 to 2000, was therefore prosecuted for war crimes by the ICTY in 1999. He was later detained and extradited to The Hague in 2001. So likewise, under the idea of command or superior culpability, military and civilian commanders who knew or should have known that their subordinates were committing war crimes were vulnerable to punishment. Finally, even while the existence of the order could be invoked as a mitigating circumstance, people who committed war crimes in accordance with government or military commands were not exempt from criminal responsibility. As a result, further efforts to convict alleged war criminals were still influenced by the rules established for the Nuremberg and Tokyo trials. So the elements of war crimes. Number one, a contextual element. The conduct took place in the context of and was associated with an international or non-international armed conflict. Number two, a mental element. Intent and knowledge both with regards to the individual act and the contextual element. So in contrast to genocide and crimes against humanity, a variety of victims, including combatants and non-combatants, can be the target of a war crime, depending on the crime's kind, or depending on what types of crimes he or she had committed. So victims of international armed conflicts, including prisoners of war, civilians, and injured and ill members of the armed forces on land and at sea. So protection is given to people not actively engaged in hostilities in non-international armed conflicts, and this includes military personnel who have laid down their weapons and others who are otherwise hors de combat due to illness, injuries, captivity, or other circumstances. Protection is also given to medical and religious personnel, humanitarian workers, and civil defense personnel in both sorts of conflicts. So for the case for war crimes, we can refer to the case of the prosecutor against Abdullah Banda Abakir Nurain. So Amis peacekeepers were attacked in 2007 by Abdullah Banda Abakir Nurain, the leader of the Justice and Equality Movement (JEM) rebel group who is accused of committing war crimes. Banda now has an arrest warrant out for him after first appearing willingly when the ICC questioned him. Trial Chamber 4 determined by securing Banda's attendance at the start of his trial in November 2004 that Sudan was refusing to cooperate with the ICC by September 2014. As a result, judges cancelled the trial's scheduled start date and filed an arrest warrant, urging both ICC member states and non-member states to assist with petitions to apprehend and turn over criminal suspects at the ICC. So for the conclusion, it is very debatable whether war crimes should be prosecuted. Beginning with the Second World War, warfare resulted in the death of tens of millions of civilians, the majority on religious, ethnic, or political grounds. Between 1945 until the end of the century, just 4 war crimes tribunals were established. The other were established to bring charges against those who are suspected of committing genocide in Rwanda and the former Yugoslavia. War crimes are significant since they have been perpetrated in almost all current conflicts. So the causes of this extend from the expansion of more lethal weapons, which virtually mandates the killing of civilians as civilian casualties, to the profound racial, ethnic, and religious hatred that underpins many contemporary conflicts. In conclusion, persistent conflict appears to leave a trail of serious violations of human rights. Therefore, ignoring the war crimes merely feeds the resentment that sparked the conflict and creates the conditions for future conflicts that will be more catastrophic than now. So that is all from me. Thank you very much for listening.